Hello, my name is Iain Larkins of Radius Law and welcome to our commercial bulletin in association with LexisNexis. The Court of Appeal has confirmed in a recent case that companies may be liable for inducing another company to breach a contract in circumstances where they know their actions will induce that breach. This case concerned a supplier that was supplying companies in breach of an exclusivity agreement. The third-party recipient companies knew they were being supplied in breach of an exclusivity agreement. The court, following a precedent from a 1949 case, ruled that simply placing orders with the knowledge that it would cause the exclusivity obligation to be breached was sufficient to make recipient companies liable for inducing the breach. Force majeure clauses commonly provide that the party wishing to rely on it must first use reasonable endeavours to overcome the force majeure event. A recent Supreme Court decision considered a shipping case where the contract provided that the shipping company would be paid in US dollars. However, due to sanctions restrictions imposed by the US Treasury, payments in US dollars were prohibited. Now, the customer offered to resolve the problem by payment in euros. But the Supreme Court, however, ruled that the reasonable endeavours proviso does not require a party to accept a non-contractual solution. The Supreme Court has given guidance on the circumstances in which directors may incur personal liability for a tort committed by the company. A tort is otherwise known as a civil wrong, for example, negligence or misrepresentation, that has caused another party to suffer a loss. Now, the key takeaway from the case is that the law does not exempt directors from personal liability for torts committed by their companies. The directors may be personally liable where they knew the essential facts which made the company's conduct unlawful and intended to procure that conduct or to participate in a common design to that end. The Institute of Directors, the IOD, is consulting on a new voluntary code of conduct for directors. You can access a link to the consultation document on the IOD website, and it is open until the 16th of August. Staying on the theme of directors' duties, an independent legal opinion commissioned by the Pollination and Commonwealth Climate Law Initiative has confirmed that nature-related risks are relevant to directors' duties under the Companies Act, and that to fulfil these legal duties, directors must identify any nature-related risks facing the company, assess which risks are relevant and not trivial, taking expert advice where appropriate, decide in good faith whether a course of action should be taken to mitigate those risks and take the relevant steps if so, and to record all decision-making in writing. The second tranche of the significant company law provisions in the Economic Crime and Corporate Transparency Act of 2023, the ECCTA, that expand the powers of Companies House came into force at the start of May. Companies House now has the power to fine businesses up to £10,000 for most offences under the Companies Act of 2006. Now, according to the explanatory memorandum on the powers, Companies House will publish guidance before it starts issuing financial penalties. Companies House has also issued new fees. Fees have increased significantly to take account of the additional requirements from the ECCTA. The new list of fees is available on the government website. Brand owners will be pleased to learn other changes made by the ECCTA will make it easier to challenge companies at the Companies Name Tribunal where they have been established with a similar name to the brand owner and where the company name has been registered for the primary purpose of preventing someone else with a legitimate interest from registering it or demanding payment from them to release it. Now, previously, companies that have been set up with a similar name to a brand owner could defend their actions by saying that it is operated under that name and it has incurred substantial startup costs in preparation. This defence has now been removed. Following the announcement of the election, the Digital Markets Competition and Consumers Bill, the DMCC, was pushed through and passed by Parliament on the 23rd of May. It is expected to be enforced in the autumn. The new law brings changes in 4 key areas. Consumer protection. The Competition and Markets Authority, the CMA, will have new direct enforcement action powers and be able to impose fines of up to 10% of global turnover. Fake reviews will be added to the list of prohibited commercial practices. Hidden fees and unavoidable drip pricing will be prohibited. There'll be new rules to protect consumers from subscription traps. Digital markets. There'll be special rules for large digital firms that have been deemed as having a strategic market status, an SMS. Merger control. There are changes to the merger control rules, including a change in the turnover threshold of 100 million, and there will be a new safe harbour for small mergers. Competition law. There'll be tougher powers to investigate and enforce competition laws. This includes more powers to gather evidence located overseas and on domestic premises. There'll be new fining powers of up to 1% of annual turnover for companies failing to comply with a CMA investigation. The European Commission has published a policy brief in May echoing statements by other regulators, including the UK Competition and Markets Authority, that competitors colluding to fix wages or agreeing to not poach each other's staff will breach competition laws, subject to some small exceptions. The key takeaways of the policy brief are that such actions are by object infringements, meaning that the Commission would not have to prove that they actually damage competition. That competitors for these purposes means anyone competing to secure the same talent, so could be businesses in different business sectors. We all know that cyber risks are a major threat to business. 2 recent government surveys has emphasised that the risks are high, but that the preparedness of companies is lacklustre. In the last 12 months, 74% of large businesses experienced a breach or attack, up from 69% the year before, with phishing attacks being the most disruptive kind, making up to 91% of incidents. A separate report published by Statista estimated that the annual cost of cybercrime in the UK was £250 million in 2023, and this is projected to increase to over 1.424 trillion by 2028. Now, despite this immediate threat, the surveys found that only 28% of medium businesses and 48% of large businesses review cyber risks in relation to their immediate suppliers. In light of these increasing threats and reports of a cyber breach at the Ministry of Defence, the Information Commissioner has issued a new practical guide titled Learning from the Mistakes of Others. The High Court has recently provided clarification that when faced with a subject access request, an organisation may withhold information about the recipients of personal data for responding to the subject access request, unless the recipients have consented to the disclosure of the data or it is reasonable to disclose the recipient's information without their consent. Now, in this case, the High Court agreed that the organisation was right to refuse to provide the recipient information, as the person seeking the data had made threatening remarks and the organisation feared for the safety of anyone whose personal data was disclosed. Last month, the ICO announced that it would not take enforcement action against Snap for its ChatGPT powered MyAI chatbot, despite its preliminary enforcement notice being issued in October 2023. The ICO had found that Snap had failed to adequately complete a privacy impact assessment on its AI tool, but it appears that its proactive approach and willingness to cooperate with the ICO has helped it to avoid any penalties. The ICO has now published a 62-page decision which provides helpful guidance to any organisations assessing similar tools. It provides a worked analysis in key areas, including on the assessment of whether an organisation is a separate joint controller, extraterritorial risks, information needed about data sharing with other entities, and mitigation measures. I'll now hand you over to our expert employment lawyer, Sandra Martins, who will take you through our key employment stories.
In the March issue, we reported that the Scottish Court of Session held that settlement agreements can settle future unknown claims if those future claims are explicitly identified in the agreement with clear and unambiguous wording. Recently, the Employment Appeal Tribunal, EAT, in England and Wales, agreed with the Scottish Court of Session. The EAT went further and held that future claims can be settled irrespective of whether the employment relationship continues or it has ended. In this case, Heathrow Express Operating Company Limited, or HEOC, offered a contractual right to a lifelong discount on rail travel if employees were made redundant after 5 years' service. The benefit was provided by a third party, RST Limited or RST. The agreement between HEOC and RST allowed for withdrawal of the benefit. In 2019, RST gave notice to HEOC withdrawing the benefit for employees employed after 1996. The claimants were made redundant in 2020. They had 5 years service but were employed after 1996 and were told the benefit had been withdrawn. They claimed breach of contract. The EAT found that the claimants' contracts did not incorporate the withdrawal provisions of the agreement between HEOC and RST because the terms and conditions issued to employees about the benefit did not refer to the agreement between HEOC and RST, or to the right to withdraw the benefit. And the claimants were not given a copy of the agreement. HEOC did not, therefore, have a contractual right to withdraw the benefit. When employees breach restrictive covenants, employers can seek an interim injunction preventing employees from doing so, provided there is a risk of significant harm to their business that would not be adequately compensated by damages. In this case, Mr. Mockford's employment contract contained an express duty of confidentiality and covenants preventing solicitation of and dealing with customers during employment and for 12 months post-termination. The employer, a supplier of fire safety goods and services, sought an interim injunction because Mr. Mockford had allegedly provided fire safety services to the employer's customers on his own behalf before and after he resigned, used the employer's confidential information such as customer details and pricing information, and approached customers offering his services. The High Court concluded that there was a strong argument that the covenants were reasonable and therefore enforceable, damages would not be an adequate remedy, and the balance of convenience favoured granting the interim injunction. Workers who blow the whistle are protected from detriment and dismissal. Workers who have done a protected act, such as bringing a discrimination claim, are also protected from victimization. Mr. Musa M. supervised passengers at ticket barriers. In 2013, M was dismissed and claimed unfair dismissal and victimization. M was reinstated and in 2018 claimed the passenger had assaulted L, a colleague. The employer found no evidence of assault, conducted a flawed investigation, kept M suspended but allowed L to return to work, and later issued a first written warning despite dismissing most allegations. M claimed victimization and detriment. The tribunal and the EAT on appeal found that M was subjected to detriments and victimized in 2018 because of the 2013 claims. There was a negative collective memory of M, who was labelled an agitator. And HR influenced the decision maker, who was unaware of the 2013 claims, which led to M being treated unfairly. That's it for this month. Thank you for tuning in. We have included links to all the documents we refer to today in the written version of the bulletin. But please don't hesitate to reach out to me or any of my colleagues here at Radius Law for more information.